May I, my lords, take a minute, my lords? Yesterday, that matter, DDA tree felling matter, which came, my lords, for another member to be appointed, my lords, for the vacancy created by Mr. Ishwar Singh, who has gone to NGT.
Oh, that's it.
My lords wanted us to suggest some names. We have two names, my lords, with some write-up also we have. My lords can consider, my lords. It's really for my lords to decide. Two suggested names. Anything my lords can take out.
Do you have any idea what is the profile of the remaining two now left out members?
One is Mr. Pradeep Kishan, and the other person is Mr. Limaye. What is
Madhu Limaye.
not Madhu Limaye.
It's an IFS.
What is one is Indian Forest Service
Indian Forest Service.
and other?
Pradeep Kishan is an ecologist. He has written books and all that. In fact, Trees of Delhi, he is the author, Manoj. He is the author of that book.
Madhu Limaye.
Sunil
Sunil Limaye.
Limaye.
Limaye is the judgment.
Both are outstanding persons.
It appears to be, Manoj. So, in fact, my friend had some knowledge about the work done by them.
Both are very good. Advantage of Mr. Sinha can be that he has worked at the ground
Yes.
in this very area.
That's correct.
Because he has been serving in Haryana cadre.
That's correct. That's correct. It is entirely my lord's decision.
Suggestions.
These are just
Out of the serving two members, one is already an ecologist.
that's correct.
So we nominate MD Sinha.
Yes, yes, Your Lordship.
इसमें कल आया था तो on the recommendations of the learned Micos Sri Guru Krishna Kumar Singh Advocate learned Micos has suggested two names. Ishwar Singh has gone to NGT.
Yes, Manoj. Ishwar Singh.
Has pointed out that one of the member of the expert committee, Mr. Ishwar Singh, has joined as a member of National Green Tribunal. And as some new appointment in his place is required to be made. And as such a new member of the expert committee is required to be nominated in his place. See, and Madam, I have suggested two names. Suggested some names out of whom we give it approval to nominate CMD Sinha, Indian Forest Service Inspector retired, former Principal Secretary, Department of Heritage and Tourism, Government of Haryana, as one of the
Very well. Just one other thing I wanted to point out, Manoj. Really, as a fallout of this matter, when the original contempt was initiated, another bench of my lords, headed by my Lord Justice Oak, had suo moto initiated proceedings for greening of Delhi, my lords, and passed several orders, including appointing the Forest Research Institute as the agency with that expert committee, my lords, to oversee the entire exercise, including the budget, etc. Various directions have been passed. I was going to circulate a note, my lords, for my lord's consideration.
that matter.
No, that matter, my lords, is really coming out of 4677, so it's really before my lords.
Please tell us immediately you like this one.
That's correct. What I'll do is
It
this.
should have been along with this matter.
Actually, my lords, it was coming. It was heard with this matter. Then, my lords, the contempt got listed before another bench.
Let me fix. If you have the number, madam, you have.
I'll just share it with the.
So give the number.
Yes,
We will not wait for the next day.
Yes.
We'll list this matter next week,
right.
just for a directions only.
Yes,
And then immediately now that you have told me, then I have something in my mind.
Right.
We'll try to do, and then we list along with that.
that's right, my lords. That's right. We'll, in fact, give the latest order, my lords, which has been passed in that.
Oblige.
You just give the number. We'll
Yes.
list it next.
Oblige.
And maybe that, maybe some relevance of this Delhi AQI,
That's correct. It will have a bearing, my lords. It will have a bearing.
some interconnectivity.
Absolutely. Absolutely.
Will it? So Monday then let this matter be also on Monday along with that.
Yes. The scope of that order proceeding is really two things, my lords. One is census of trees. The other is, my lords, greening. So greening substantially will have a bearing
when we
on.
are fighting for a improvement of AQI,
Absolutely.
greens are
Naturally will be part of that.
one of the most viable and
Absolutely.
most effective long drawn solution.
Absolutely. Absolutely. We'll just give those details, my lords. Deeply honest.
Thank you.
Your Lordships, I'm seeking liberty to mention an application.
We have stopped.
Manoj, let me try and persuade the court. Manoj, 6 presiding members of DRTs across the country.
Let it be done. File the application. This mentioning part is not entertained. File some applications.
Manoj, we filed the
First
application.
you file mentioning, then some early hearing, then matter listed, then
Manoj, we filed the application. I'm
only
only
how the consumer of justice is being consumed.
Manoj, we filed the application, Manoj. I'm only saying it may be listed because they'll retire.
We'll list the amendment, we'll see. Item 1.
Please, my lords.
My lords, here my lords have issued limited notice in respect of petitioner number 2 and 3 with quantum of sentence. So, my lords, it's listed today for directions. Otherwise, my lords have granted leave. So, I was, my lords, wondering, they've already undergone, and accused number 1 has undergone his full sentence today of 10 years. The relevant part, my lords, that I would have been relying upon at the time of this matter was, if my lords will see page 5. Now, these two ladies,
What is listed today is main case.
was it shown for directions?
Direction. So these are where the sentence is undergone.
Fellows, I will be praying if it can be done as sentence has undergone. They have undergone some sentence already. And if my lords will look at page 5, this is most absurd.
No, if you want, we can finish the matter by.
My lords may do it sentence has undergone for these two. And one of them is extremely sick now. She may not even be survive it also.
Any serious objection?
Malas have issued a limited notice, Malas, with
All right.
quantum.
We have to get rid of these matters now. Ultimately, occurrences of 1990.
Malas, I've gone through the
And my
facts.
lord's order-
I've gone through the facts, Malas. I'll leave it to the court.
My lords granted bail in 2016.
And in any
Today
case,
we
we are
are
not
quite 10 years
acquitting.
there
We are
also.
not acquitting.
Malas, the nature of the offense is serious. However, in the peculiar facts, I've also gone through it, Malas.
No,
I'll leave it to the court.
definitely. Offense is very serious. No,
Yes.
therefore,
Therefore, Malas,
therefore, there is no leniency.
yes.
It is only balancing that when you uphold the conviction, then on the question of sentencing when comes,
Yes.
then you can always consider some mitigating.
I mean, I must point out, Malas, what it's a case of concurrent conviction and 10 years. She has undergone around 1 year, 7 months. However, if I go through, if Malas may go through the facts, Malas, I'll leave it to them.
It's 2 years, I believe.
1 year, 7 months is what I've been
We
told.
could have some information, but I'm instructed about 2 years, and with remittance it will be 4 years.
He was 15 years, 7 months, Malas.
Because they will be
Extends
much
up
to
to
be
10.
said if we have to argue, but they're willing it, my lords.
There is a minimum say.
My lords, they won't be because here the conviction is 363 and 366. That is kidnapping.
No, Malas, I must point out.
375 where she is concerned because that man.
I'm clarifying that, Malas. I'm clarifying. I'm saying conviction is under 366, which may extend to 10 years. It is not under 376 for them.
It's not for
It's under 366,
Like main
which can
accused
extend
has
up to
under-
10 years.
This
The main
woman accused.
Yes.
So, out of the, what is her name?
Anita Bain, Malas.
because one is
And Manisha Bain.
and Manisha.
A5 and A6.
Ladies, they must be only for
Their SLP is dismissed. Conviction is confirmed up till this honorable court.
And he is undergone and he is now released also. I think.
Yeah. What was the name of the main accused?
My lords,
Rashmi
Rashmi,
Dilip Singh and Rashmi Bhai.
No, the male accused.
So A6 Melons, who is petitioner number 2 here, she is the wife of A2, the one who actually committed the rape.
You never know. She also might be.
being accused in
Well, it's considering the age of the girl and her.
is Rashmi Himmatlal Dave. My lords have page 142, the trial court judgment. For a moment, my lords will find the list of accused there. Page 142, my lords. So, my lords, Rashmi Himmatlal Patel was the Dave.
Just a minute. The main accused and guilty of 376 is Dilip Singh.
Only Rashmi is guilty of 376 and he's undergone the sentence, the full sentence. My lords, Dilip Singh,
363.
He was charged for abduction, Melons.
he was
kidnapping and
charged for
abduction.
363.
Yes.
Yeah.
And Rashmi herself is also dismissed.
Also dismissed.
Babu Bhai,
He's
My lord,
dead.
he's
Melons.
not before the, he died.
But he died.
He died during the High Court while the matter was pending.
and
He died.
this Patel, just Bhai,
4 is also dead, Melons.
eh?
3 and 4 are dead.
Appearing for four.
Dead.
Yes.
We are then appearing only for.
Now comes Anita Bain.
Yes.
5 and 6.
My lords, it survives only for 5 and 6. Today.
5 and 6.
Only 5 and 6.
is in the 5 is the condition. Now just come to the relevant page where what is the finding about these two?
Yes, my lords.
Yes.
That also. So, my lord, so far as 175 is 375 is concerned, they have not been convicted. 172, my lords, page 172. That's the trial court. My lord will find, and their conviction, my lords, is here in 172, last paragraph.
Well, the girl after kidnapping was kept in the house of A6, who is petitioner number 2. And then she was taken from one place to another. This is the primary allegation against these two. That
It's
the,
all right now, but don't highlight too much.
no, Melis, Melis had asked Melis what is the role ascribed to him. That's all. That's all.
This is not clarification. 1991. 16 years old victim had gone to fetch water at the public tap situated near the refinery course road in Vadodara. She did not return home for considerable time, from which naturally prompted her father to lodge a complaint with Jawahar Nagar Police Station, District Baroda on 25th November 1991. Not father, mother. The complainant mother thereafter noticed light switched on in the house of accused number 1, which was closed on front side, and when she went on the back side and peeped into the house through a window, she noticed her daughter along with 3 persons. Next paragraph. Further investigation in the case led to so after the investigation, a charge sheet under section 363, 366, 376, 323, 506 and bracket 2 IPC was filed against 6 accused persons, including 4 the women appellants. The prosecution successfully established that accused number 2 was guilty of committing offence under section 376 IPC, whereas both the appellants, along with accused number 1, were guilty of offences under section 363 and 366 IPC. Accused number 4 and 5, 3 and 4 died during trial or after acquittal.
After trial, at least number 3 dies after trial when the matter opened.
Subsequently passed away,
Yes. 3.
and hence it is not necessary to refer to the role attributed to them. Next paragraph. The tragic story is that the first appellant is wife of the main accused against whom charges under section 376 IPC were proved. It is also a matter of record that concurrent conviction and consequential sentence awarded to the principal accused and some of his co-accused has already been upheld by this court in SLPC criminal number 761. Next paragraph. Regardless thereto, a leave was granted in the instant appeal in order to revisit the culpability of the appellants and proportionality of sentence. Both have been released on bail.
Yes, I beg your pardon, ma'am.
Yes, ma'am.
Both have been released on bail.
Both were released on by bail by this court. My lords,
Both of them.
order
Both of them were considered
of 15/11/2016. Of 15/11/2016, my lords.
Next paragraph. We have heard once in a council on behalf of the appellants, as well as one state council at considerable length, and have scrutinized the evidence of the court with their able assistance. Though the contention that first the appellant would not have to become party to the commission of the by her own husband. Though it seems effective that it was merely impossible for the first appellant to conspire with her husband to commit rape on the victim. We find that there is overwhelming evidence on the court to suggest that the occurrence took place on which that in the occurrence that the appellants have been attributed that the appellants have been accused of assisting in raping of the victim.
And her movement to various places after the incident. ठीक है, उसके बाद प्रिंसिपल एक्यूज्ड का फादर का हाउस में उसको
Chapter 676 is said to have been committed.
after the commission उसको secret कर दिया.
And was kept at the house of the principal accused after committing the offense under section 376 of the evidence has been critically appreciated by the trial court as well as by the high court. In the concurrent finding of fact with respect to the role attributed to the appellants. In such circumstances, and knowing the scope of interference in a finding of fact based upon appreciation of evidence by this court in exercise of its powers under 136, 171. We are satisfied that no case to interfere with so far as conviction of the appellants is concerned, commenced by doubt. Next paragraph. We have also heard Planning Council's proposal for the parties on the quantum of sentence. The appellants, both the appellants are women, thus belonging to a poor strata of society. whether they willingly participated in the occurrence or the dominance of the male members of the family forced them to do so is a mystery. Or to forced to do so is a star question. Is a star question. Which many a times has to be answered. Taking in review the socio-economic conditions of the co-accused. There are no criminal incidents. Both have undergone sentence of actual sentence of nearly 2 years. Their conduct post grant of bail about 10 years back is also is also not blameworthy. It seems to us that no effective cause of the administration of criminal justice system will be served by directing the offenders to undergo a reminder of the sentence at the censor of their life. Consequently, from keeping in view the particular facts and circumstances of this case, the fact that the appellants are women, that they belong to poorest section of the society, that's that they are not the main accused, and there are multiple mitigating circumstances on the code, we are inclined to reduce the sentence to the extent you have already undergone. We ordered accordingly. The appeal is allowed in part. The sentence awarded to the appellants by the trial court or the High Court, as confirmed by the High Court, is consequently reduced to the extent of the appeal that you have already undergone. The involved punished by the appellants are accordingly discharged unless they are found enrolled in some other case.
Please put some grapes. And your next friend wants to clarify. I heard if my lords have said sentences that are wrong.
Well, please. As per the last order, my lords had asked me to appear before the authorities. I've duly appeared there.
Anyone appeal?
On payment of GST. GST नहीं दिया था इसलिए.
Well, it's appearing, my lords. My lords, he had in fact appeared, my lords, and he had participated, my lords, and he has been asked to bring certain documents as well, my lords. My lords, I leave it to my lords, my lords.
All right, thank you. See, the State Council clearly submits that pursuant to order dated 13 February 2026, the petitioner has joined the investigation. He has been asked to produce some documents to which he has agreed to. I am concerned for the petitioner state that the petitioner will continue to cooperate with the ongoing investigation and will appear as and when required. That is so, with the order dated 13 February 2026 actually, petitioner shall remain on the arrest phase. He will be pronounced question.
My lords, with the liberty that in case he doesn't cooperate, my lords, we may move the appropriate court, my lords.
It is already there. Always there. Where is?
Grateful, my lords.
My lords, item 3, I'm seeking a passover. My lords, I appear for the state. Mr. Luthra is leading me. I'm seeking a passover, my lords.
Very important legal issue, my lords.
Yes, this is something very serious, my lords, not like the...
The connected matter, your lordships have, or your lordship, this is similar issue, my lord, pending. Your lordships have.
My lords, there's no similarity.
This is the order passed on the connected matter.
matter.
Leave this matter at all the connected matter before a bench of 3 honorable judges. There is an order passed by this honorable court, not here.
It's a joint matter.
I'm for the
What is
victim.
the
my
point? What is this matter?
Whether after the return of the charge sheet filed, but whether petitioner is accused entitled for default bail. That issue.
At the time that the default bail was granted, my lords, the accused was a ruling party MLC. I am the deceased's mother. The police filed it on the 92nd day, right to default, and when a writ petition was pending in the High Court, and I'm the driver.
But he is on bail. He is on bail. Occurrence was in 2022. My lord were pleased to grant bail, interim bail. 22 onward he has been on bail. Not the investigation was completed. Recently, 2-3 days before, final charge sheet was filed after further investigation.
He has been released on interim bail.
My lords, I will explain what has happened. This is something very, very serious and much more than meets the eye. The accused, there was some level of collusion. I will not go further than that. A charge sheet was filed. A charge sheet was returned, my lord.
Who is this accused?
Accused is the petitioner.
He is
A1. He is an MLC.
That we understand. What is the background?
He is an MLC.
Of the then
The then ruling party continues to be the MLC now. He is an extremely influential person. My lords, I'll explain the sequence of facts. Although I am seeking for a passover, my lords.
And the murdered victim
My
was
lords.
his driver, my lords.
There was...
Postmortem.
My lords, a charge sheet was filed.
Until now, cognizance has not been taken of the charge sheet. Trial has not started. It is leading to...
My lord,
to a miscarriage, my lords.
My lords, a charge sheet was filed within the stipulated period. Stipulated period returned only for want of some FSL report. And default bail is granted. 3 years.
No, we understand. The prosecution was hobnobbing with him.
Now we have
They
recently...
deliberately do not file the charge sheet along with.
Now we have filed the supplementary charge sheet, which is extremely damning. My lords,
But with my friend's permission, though she's doing a better job than I am not.
As
always.
definitely.
As always.
And
As always.
particularly
Young people better always.
Better job.
I'm the murdered victim's mother, my lords.
Lord, it's actually quite disturbing. I want your lordship to see the injuries.
Problem is now tell us. 2022, this court grants bail. What face we cancel the bail?
Well, Lord, I understand, but
Expedite.
consider one thing, Lord. I must tell your lordship 2 things. Matter comes up, Lord. Interim was
And
granted.
we have never been able to appreciate. Now I am surprised I am getting matters every day listed. In bail matter,
Can I make
we are granting interim bail leave granted. But bail matter, what is there to grant the leave?
But-
Dispose of him with one line order.
Can I just show your lordship one thing, Lord? I want your lordship to see, Lord, in the counter affidavit of the private party, Lord, page 176. For a moment.
The victim's...
Victim's counter.
Yes.
R2's counter.
R2's count. Preliminary counter.
And Lord,
Stage of the trial now.
It hasn't started.
I'll tell your lordship, one charge sheet was filed earlier, Lord, finally after all that struggle. And I must tell you, and Lord, then the second is now being filed, Lord, because unfortunately, as your lordship said,
Look, you are great police also.
Lord, we had a problem, Lord, your lordship will understand, because in a case like this, Lord, to file a defective charge sheet, and on defect of what? FSL, and the court returned it, Lord, and there's the sheet where which the return has happened is quite disturbing. It goes up and back, up and back, up and back. And the Andhra Pradesh High Court had taken a view much earlier in 2009 that a charge sheet, even assuming it is returned for defects of a technical nature, the refiling with correct particulars relates back.
Mr. Luthra, his court in 1980, Satyanarayan Musadi
Hello.
said if the charge sheet complies with 173(2), accompanying documents there or not there does not change the character of a charge sheet. Law
I
is very
understand,
clear.
Lord. But the law is
The
clear, so not.
thing is on facts. He's been on bail from 2022. We'll keep this issue open and.
Lord, can I make a suggestion? Can I
Is
make
there
a
any
suggestion, Lord?
allegation from 24 till 26?
Can I
misuse
make
of
a
authority?
request?
So-
Can I make a request, Lord?
Earlier now you are blaming that he was politically affluent and this and that. What has happened after you? came
Lord,
into
Lord,
power?
what happened was, Lord, we came to power, the power change in 24, Lord. After that, this file was revived, Lord.
Mr. Luthra, 24 to 26, your police is filing second charge sheet only.
Yes.
What action have you taken against them?
Lord, we could only do
What
that,
is
Lord, because the
the
matter was
system?
pending here. Lord, matter was pending here.
In
In
a
fact,
murder case where a political person is involved, where you are making.
Lord, just see the post-mortem, Lord. Yes. Lord, can I show your Lordship one document, Lord? 31 injuries.
Have you issued even a show cause notice? Forget about suspension of a police officer who have not completed investigation for all these long years. Please show us.
Lord, I must tell your Lordship, I put
Because everything you want to be.
no, Lord. I put this.
Because these are also.
My Lord,
very
my Lord,
good
may I just say this?
political,
May I just say this, Lord? May I just say this, Lord? I put this question to the officers yesterday. Have you taken any action? He said the first task.
What authority a DGP has to continue if he cannot control a superintendent of police
But
or the IO.
first-
that you
First
seek
task
his
was to take
explanation.
back the documents and get hold of the documents because the documents were.
First, you should initiate a discipline proceeding.
Yes, Lord. Lord, I put it to Lord.
See what is.
Lord,
I put it to them,
don't
Lord.
have any material that means you are
My Lord,
fabricating report against him.
may I make a suggestion, Lord? I put it to them, Lord. I'm given to yesterday, Lord. This conversation happened, and the officer had to get back because the investigating officer was only on call when I discovered this impromptu.
It is not look at the
Right now.
I understand, Lord. May I just say?
May I place one subsequent
Lord, can I
fact, my lords?
just
As-
can I show you one document, Lord?
No, we will not see anything. We will-
My lords, as the victim's
Lord-
mother, I may be permitted to say something.
If
That
you are incapable, we can transfer this investigation to CBI.
Today, the supplementary charge sheet has been filed, which is all the documents. I've got it, Lord. I'm carrying copies. Cognizance has not been taken.
My lords, cognizance has not been taken. Trial hasn't started. The trial must be expedited to close within 6 months, so that will serve the interests of the victim and the
No, not let this. Not may I just say this? Not let the man be in custody at least till the major witnesses are examined. Not otherwise, in a 302 case, his wife not had got an order from the High Court because there was a notice given to her. That matter was pending.
Everything you want to settle inside the courtroom only. Outside courtroom, as if the state and its authorities have no duty of knowledge. There you want to have a collision, you want to appease someone, and here you want everything.
Lord, we can only plead with your Lordship. Lord, I must tell your Lordship, there was a gap. I understand. But Lord, today, I'll get that instruction is all I'm saying.
Police officer like this.
I'm sorry, Lord.
With a police officer like this, save the prosecution. Forget about his bail.
Lord, fortunately, there's been a change of the officer. We changed the officer. There's a new, young officers come in.
my son
Young
was
officers come
murdered,
in.
my lords. I'm the mother. The trial hasn't started. Charge sheet has not been taken cognizance of. He was a driver working for the ruling party MLC.
Being granted, the appellant is stated to be a sitting member of the Legislative Council in Andhra Pradesh, belonging to a political party now in opposition. He is accused in FIR number 195/2022 registered under section 302(201)34 IPC, section 3112 SC/ST Act, police station Silver Parvaram, EZ district. As consequences of the fact that any observation made by this court at this stage might cause prejudice to parties. We have no reason to doubt after reading the implement orders that the police/stroke investigating agency has been hobnobbing with the appellant accused. All efforts have been made to offer bail to him on platter, though the High Court did not grant it. Next paragraph. When the instant petition came up for hearing on 12th December 2022, this court granted leave and directed that the appellant be released on bail. यहाँ पे लिखा था ऊपर तो ऊपर platter bail in default bail under section 167(2). 167(2) CR. उसमें वन लिखा ना, however the High Court may not grant the same, giving rise to these postings. उसके बाद ये आएगा फिर on so date and release the appellant on bail. He is thus enjoying the benefit of interim bail from last more than 2.5 years. Next, for on a repeated query from Mr. Siddharth Rudra, learned senior counsel for the state of Andhra Pradesh, informs that now a supplementary charge sheet has been filed. This again shows, this again shows laxity, if not complicity, of the state police in state police in the accused, exhibiting the grossest negligence in the matter of investigation of an heinous offense. That's further. In order to strike balance between the right to liberty on one hand and fair trial to the victim of the crime and his family, we will dispose of this appeal in the following directions. One, I will request Honorable Chief Justice of Andhra Pradesh High Court to entrust a case, entrust the trial to a fairly senior judicial officer who shall take up it on weekly basis. Why? The issue regarding framing of charges must be decided before 13th March, before 14th March 2026. Next paragraph. After framing after the issue regarding framing of charges is resolved, the prosecution is directed to produce all the witnesses to conclude its evidence as early as possible, but not later than 4 months from the date, from the first date. How many witnesses you have?
But may I say, madam?
58.
58 witnesses, madam. May I say, madam?
What 58, bro? First and second.
May I say one thing, madam?
That is another way of
87, not 87. Total is 87.
Subject to
a prosecution case, then you have a long list because
87.
Long rope to
Lord, may I just say this?
to run away to this and that.
Not the High Court was not just seized. Not there was not the High Court was seized of it. Not there is a. I'll just show Lordship. Not there were directions given by the trial court not for further investigation as late as not the July of 25.
This is what exactly you want to entangle. Your intention is also not to bring the guilt home. Your intention is
Today,
this is a new trend that you keep person under trial, keep him inside, and blame him. That's what.
but I can show your Lordship the supplementary charge sheet. It is I would say fairly comprehensive.
The charges का लिखा था. Number 3 direction, simultaneously, if any further investigation is required, the same shall also be completed within 2 months. By 31st March कर दो. By 31st March 2026. उसके बाद charges का कर दो. Charges will be framed by.
Shall be heard and decided. Heard and decided. Not otherwise they'll come back.
But may I make one small submission?
The issue regarding charges shall be decided by 15th April.
Inquiry.
By 18th April 2026. Next paragraph. The prosecution shall be directed to produce the entire evidence within a period of
It's May.
4 months.
But may
Within a period of
I
4
say one thing, my lord? May I say one thing, subject, my lord, I appreciate.
The only choice is will cancel the bail.
I'm not
Put
saying,
you inside.
but I only saying, but I only bring to your lordship's notice. Even number 207 copies have not been furnished so far. They have filed only charge sheet today. I don't think that they will be in a position to use the same. So I only bring.
That is by on or before, I will say by 31st August 2026. Next, for the trial court shall grant a reasonable time to the appellant with defense evidence within a period of 2 months. Next paragraph, the trial must come to an end by 30th November 2026. Next paragraph, we request the portfolio come administrative judge of the High Court to monitor the ongoing trial only for the limited purpose of compliance of the directions issued herein above.
Don't have, we can
Issued herein above.
they know it.
Next paragraph. The evidence prosecution. Firstly, the eyewitness or other vital witnesses should be examined. Next paragraph. The continuation of bail of the appellant's continuation on bail shall entirely depend upon his conduct during pendency of these proceedings. If it is found that he made any direct or indirect attempt to influence the witnesses or tamper with the prosecution evidence, the necessary consequences must follow. The necessary consequences must follow. Next paragraph. जहाँ पर आता है उसी में ऐड कर देना with a view to facilitate the conclusion of trial in a time-bound manner, the High Court is requested to spare the officer largely from other responsibilities, other matters, so that
25.
the current trial proceedings can be taken up at least once in a week. At least once in a week.
Lord, can I seek one indulgence? Just see, Lord, we moved, and I must say this, Your Lordship put to me, just see, Lord, the order. Lord, one thing, Lord, we moved for investigation because it was blocked, Lord. Thereafter, we got the order. Please see that. That's on my behest. Please just see, Lord, page 5.
Not to pass any interim order, staying the trial, and if any such issue arises, the party shall be at liberty to appeal this court. Yes, now,
Lord, just see, Lord, the order I passed trial court. Not state moved the trial court asking for permission to do further investigation, and that was granted not now in July. Please see, Lord, page number 6, page number 5, Lord.
What should we do?
Lord, no, Lord. I'm saying, Your Lordship put to me that we were lackadaisical. We moved because, Lord, earlier the issue was something else, Lord.
That 3 months have also expired.
Lord, we filed it. My Lord, may I just say this, Lord? Your Lordship has passed an observation that we didn't do anything. Lord, we moved the trial court, got the permission.
Except hobnobbing.
Lord, we filed it within time now, within the 3 months, and we asked the trial court to give that order. Lord.
Complete collusion.
My lords, may I make one request?
Lord, after the administration has changed, Lord, things have been different.
Thank you very much. Thank you.
My Lord, the observations are rather harsh. After, Lord, then please record that we sought this, Lord. Otherwise, I'll be failing my duty.
That is, unless you really take them to the task.
Lord, I appreciate. My Lord,
There is a clear case of nexus of the power and the police.
my Lord, may I just request your Lordship, Lord, one thing. Lord, we moved an application on 23rd of April. Just see for a moment, page 7, Lord. I'll leave it to your Lordship.
No, we will not look into anything. Why should we look into it?
Lord, because we took steps, Lord. Lord, we took steps in April of 25, Lord, to get the further investigation reopened up. And then we got the order and we filed.
Lord, now that you have completed.
It's filed, Lord. It's filed. Charge sheet was already filed within the time stipulated.
I think we will give a compliment. We are not going.
No, Lord. I'm saying it's not the compliment. It's not the qualification that I'm worried about. Your Lordship has passed an observation that even after change, Lord, there's been an issue.
Absolutely. That is what they are doing.
My Lord, we just... anyway, Lord, My Lord, may just record that we filed the supplementary charge sheet.
We have said so. We have filed so. We have said so.
And my lords have taken care to curtail any dilatory tactics by ensuring that there will be no stay of the trial and the trial.
All right, thank you. Thank you.
I'm bound. My lords.
Deeply obliged, Lord. Grateful. Thank you.
Item 4, Malad, I have 2 minutes. Malad, out of 8 years, petition has already undergone 6 years, 4 months, Malad. Yes, Malad, he was released on bail.
Yes. The trial is still pending.
Malad, appeal is pending. Appeal is of 22, Malad, it's pending, Malad.
7 years for PG. Because minimum. Six years already.
6 years already. 6 years, 5 months, Malad. Already under.
But the appellant has already undergone 6 years of imprisonment out of total 8-year sentence.
To be precise, it's 6 years, 5 months he has already under.
For the instant appeal is allowed. The impugned order dated 12th January 24 of the High Court is satisfied.
Modified. Modified. High Court is modified upholding the conviction and reducing the sentence to separate.
Appeal is still pending. Okay. Passed by this court is made absolute. Consequently, the appellant shall remain on bail. Consequently, the sentence of the appellant shall remain suspended, and he shall continue on bail during the penalty of any appeal before the High Court. It is clarified that we are not expressed any opinion on merits.
Very good. Match up.
Your Lords, I have deposited the amount and I produced the mobile phone today morning because I traced out only yesterday night.
So I need to take instruction as far as deposit is concerned.
I produced that mobile phone today morning.
So you asked him to deposit.
He's saying today morning.
I deposited
It was
the amount.
lost.
He is also playing all mischief.
First he said it is lost.
Lost.
He said
Yesterday
that
FIR
he traced out in Bangalore and yesterday he got it and today morning we deposited before the investigation officer.
Complying with earlier rule.
Bangalore.
Only he has traced out yesterday, my Lords, with the IME number. He got it from Bangalore and he.
Has he ended over?
It's today morning he's saying I need to.
You don't know, because obviously because in the morning he said.
Yes, ma'am.
You verify it, right?
Yes, ma'am.
And you just see that he has he given some fake item or is it?
That's the reason why I.
Verify, otherwise we will dismiss the petition.
Yes.
His conduct requires dismissal, but anyway, say it is claimed that the order dated 13 February 2026 has been complied with today morning. The state council seats are granted 1 week time to verify.
Yes.
Post the matter was also there.
I have deposited 30,000 also.
Let us see.
Your Lordship, on the instruction, we wish to withdraw the SLP.
Withdraw. Or
Yes.
Transfer for the petition. Submitted to withdraw this petition. Is granted.
May it please your Lordships. Please, Minister.
So I appear for respondent number 2 in this matter, which means I am seeking 2 weeks' time to file my counter affidavit.
What was the matter before Justice Sundarai's bench?
My Lord, this was Justice. That was the issuance of notice. My Lord, these are 3 challenges to 3 separate bail orders. These are the 3 conspirators in the murder of my brother, the deceased. It was the second 2 SLPs, SLP 2 and 3, that is accused Rekha and Subhash. These were listed for notice before Justice Sundaresh.
At least the use of cancelling.
October, my Lord. My Lord, my only grievance as brother of the deceased is there are threefold reasons, my Lord.
So the pre-trial detention will be punishment for them?
My Lord, parity is given to the main accused.
Forget about parity. Rightly, wrongly, he has been on bail. There is no allegation of misuse. We are not going to.
My lord, there is a complaint. There is a complaint post bail.
Let that be inquired into, and if necessary, you take it.
If there is a misuse of concession of bail, for that you have to go to the High Court for consideration.
My lord, my only consideration that I felt my lords would eat was.
We can grant you liberty that in case there is any instance of misuse of concession of bail, we will be at liberty to approach the High Court for cancellation.
Then my lords may grant me liberty to approach the.
Say, in the instant as the instance specially petition is directed against over the 17 December 2024. And so on. So there are whereby the respondent accused them can grant regular bail. One of the ground taken is the alleged misuse of concession of bail. While we do not find any ground to interfere with, while we do not find any valid reason to interfere with the order granting bail to the accused, liberty is granted to the petitioner complainant to approach the High Court for cancellation of bail if there is a specific instance of misuse of concession of bail by the accused. So, liberty for action perspective.
Grateful, deeply obliged.
May it please your lordship.
Your Lordship, I'm seeking a short passover in this matter. I delete.
Not password, then we'll take up on some other day.
Please, your lordship.
You are on bail.
Some other day, Mother.
Yes, it's on
You are
bail.
on bail.
But this needs consideration, my lord.
Yes, my lord. Putting it on another day. That's all.
In due time.
This has become purely academic now. Lord, I may only point out, this Honorable Court, by way of an order, has permitted further investigation and recently even extended the time. So it's academic on both counts. He's now on bail.
We will examine this because
My lord knows, Mother, the section 44, Mother, your lordships have been
very well.
Yes, obliged knows.
Mr. Jetmalani, we will take up this matter next week.
the other one, my lord, that is 10. This is 8, that is 10.
This was Mr. Jetmalani is.
That's item 10, Mother.
That cancellation
Sure,
of
but
bail.
we will take up.
Mine is 10.
As my lord, please.
Against the bail.
Against the bail.
Yes, that's challenging our bail. Granted by a detailed judgment of system.
I'll point out how detailed.
Every aspect has been considered.
We will take up on some other day, not on a Friday. We can take about it.
Yes, that be better, Mother.
So 10 also.
Obliged, my lord. Deeply.
So grateful.
Then be adjourned.
That's all right.
10 also.
Get time for this.
Well, your Lordship is keeping 10 also after the break.
I'm over. Please, my lords. Lords, in this, from me, the recovery is there of 5 kgs of ganja, which falls under intermediate quantity, my lords. And the prosecution.
Only 5 kg.
It falls under intermediate quantity, my lords. And the prosecution witness, who was the Caesar witness, also here.
Some regrets that your recovery is too small.
No, my lords. Even the independent witness who has been examined, who happened to be the Caesar witness, he has turned hostile, my lords. He has not corroborated with the story of the prosecution, my lords. And 3 persons on a bike carrying 30 kg of ganja and 4 bags.
Motorcycle, why not? Between the two sitting, 30 kg, what is the 30 kg?
On a bike, my lords.
Bike?
And 4 backpacks.
You are talking as if we are coming from some different part of the world.
My lord, from my possessions, my lord, it is.
You are talking bicycle or motorcycle?
Motorcycle.
So you can carry it to 30, 40, 100 kg even on bicycle in India.
3 persons were also sitting on that bike, my
It all depends upon their power of pedaling while sitting behind.
Yes, my lord.
The witness, which is the Caesar witness, he has turned hostile, my lords.
That's a difference. I've done married, but 5 kg and 30 kg.
There is a violation of section 105 also, which says
How much time you have spent?
11 months. Till today, my lords, 11 months, my lord.
My lords, 12 witnesses out of 11 have been examined.
Out of 11 has been examined.
11 have been
My lord. May I correct one thing? It is an incorrect statement. These are the order sheets of the learned trial court. Out of 12, only 6 has been examined, my lords. These are the order sheets of the learned trial court. And the learned additional superintendent of police is making this deposition before this honorable court that out of 12, 11 has been examined. Kindly have that order sheets, my lords. 6 have been examined and 6 are left, my lords. And they are not turning up for the examination, my lord. There is the order sheet.
It is less because he is operating.
We have filed a counter, my lords. There are 4 other antecedents. 5 though with not of NDPS, but they are. And he is resident of state of Rajasthan.
Again, my lords. At page number 16, my lords may kindly have at page number 15 and 16 of their counter affidavit what they have stated. Crime number so and so, offense so and so. They have not even mentioned the PS, police station. They have not mentioned the date. In each and every one of the FIR.
You are aware about your.
No, my lord. There is no criminal antecedent, my lord. Because of this fact, their trial court order is there. While my bail was dismissed, this observation has not been recorded. In the High Court's order, also in the impugn order, this fact has not been recorded because there are no such cases. One FIR is of 2029, my lords. Kindly have serial spelling.
Earlier you were in Excise Act, now you have come into NDPS Act.
Not a single FIR against me, my lord.
You are upgrading yourself.
If in that case,
pressure has also increased. Earlier we were confined to Rajasthan and Haryana. Now we have gone up to Chhattisgarh.
My lord, the state of Rajasthan has issued me a certificate, character certificate, where they have stated.
Rightly so.
So, my lord, these FIRs may be brought on record. I am stating that if these FIRs are against.
No, certificate for the original manufacturing.
No, my lord, character certificate that I don't bear any criminal antecedent. They have stated. And kindly see these FIRs. Even the PS is not mentioned. Which police station is this? Not even mentioned the PS, not even date is mentioned. One is of 2029, serial number 4, my lord, crime number 5 of 2029, my lord. Right now we are in 2026.
The appellant is an accused in FIR number 101/2025. Registered under section 20 in brackets small b of the NDPS Act at police station Jagdalpur, Bastar district, Chhattisgarh. The appellant is a resident of Rajasthan. The prosecution case is that on 21st March 2025, the police received an information that 3 persons carrying approximately 4 kilograms of ganja were traveling on a red motorbike in the area. They were intercepted. On such 30.84 kilograms of ganja in 6 packets of approximately 5 kilograms each are stated to have been recovered from them. Their bags, mobile phones, and red bike were also seized by the police. And all of them, including the appellant, were arrested at the spot. Next one. The appellant's main contention appears to be that only one packet of 5.124 kilogram is said to have been recovered from him, which is below the commercial quantity. Next paragraph. The High Court filed impugn order dated 27 June 25 has declined bail to. Next paragraph. You have heard the reports for the party. Record to use. While it is not expedient to express any opinion as to whether the appellant, being one of the pillion rider, would be deemed to be in conscious possession of the entire quantity recovered from them, or such quantity shall be confined to 5.124 kilogram only. As such an issue shall be decided by the trial court in due course of time. While he is straightforward, at the outset, you are not inclined to explain, you are not being it expedient. That's however, taking into consideration the period spent by the appellant in custody, and the fact that conclusion of trial may still take some time. One instead of feeling allowed to include order of the also to set aside, and the appellant is directly to be released on bail, subject to its pronouncing bail bond to satisfaction of the trial court. First, the appellant shall furnish adequate security to ensure that he remains present in court on every date of hearing unless granted exemption. Order of court. Let him now go on being, because otherwise trial court will come under pressure.
My lord.
To decide trial in 1 month, 2 months.
Oblige, my lords.
My lords, this is a matter under the Foreigners Tribunals Act. In this case, my lords, even though there is evidence from my mother's side, my mother, my maternal uncle, my grandfather, the tribunal only considers my father's inapplicability. Here, my father has passed away. He had a mental health issue. He passes away. The Gaombura documents my birth, documents my lineage. The Foreigners Tribunal does not consider that either, my lords. May I just take you to my written statement, my lords, which was filed before the tribunal, annexure P11, my lords. And then I'll take you to the Jamabandi also, my lords. P11, page 80, my lords. My lords have this?
Yes.
Yes, may I read, my lords? That the second party father, Mokshed Ali's name has recorded in the NRC of the village of Barbuza in the selected district of Barpeta, Assam, and then second party's father shifted to Kajhar village in the district of Barpeta, Assam. It is stated that the second party's father has expired in the year of 73. The second party's mother came back along with the second party's brother, so-and-so, to her maternal grandfather, late Kalimuddin's house at so-and-so village in the district of Barpeta, Assam, and second party's mother gave up all relations with second party's father. Para 6, that second party's father had a mental health disorder, so his name was not recorded in the voter list of 1966 and 70. And my lords may now see, my lords, the annexures that we have attached, which show, my lords, annexure P1, page 33. My lords, we prepared a chart for you, which shows the maternal grandmother in 1966, 1970, the mother, 1985, annexure P4, 1989, annexure P5. Maternal uncle right through, my lords, all the years. We've just prepared a chart for you. The issue here is, my lords, the Foreigners Tribunal.
No. You please connect yourself with any of the documents. What was your father's name, first of all?
My lords.
My mental derangement.
Moksha.
He died when the twin mother was pregnant.
My father dies, my lord, of cholera while my mother is pregnant with me. Then my mother goes back to her maternal home. The issue with the Foreigners Tribunal order, my lords, and this is a common issue, is they don't consider the female lineage. which is all my relatives from my mother's side.
No, they may consider not. You please establish your link. That how
Yes.
are you?
May I just take you, my lords, to the first annexure, P1, my lords. May I just trouble my lords with that? P1, my lords. This is the certified copy of electoral roll of my maternal grandmother. That's the table we are handed over, my lords, explaining all the annexures. My lords has this.
Yes.
So each of the annexures, my lords, we have attached one piece of identification of the maternal lineage. So P1 is my maternal grandmother. This is a certified copy of electoral roll from 1966. Your Lordship sees this, my lords. 1966, it says the following details are hereby confirmed as per the electoral roll, and this is my maternal grandmother. Now, if I may take you to P3, this is similar certified.
No, on what basis you establish that she is your maternal grandmother? That is the point.
She is shown as the wife of my grandfather, my lords, page 34.
Well, how you establish that he was so and so was your grandfather?
The Jama Bandi, my lords. The Jama Bandi is annexed as, my lords. Please see the Jama Bandi, my lords. A12. P12, my lords. The Jama Bandi, my lords, knows, my lords, in villages, the Jama Bandi documents entire lineages of families, including births and deaths. Please see the Jama Bandi.
They have nothing to do with birth and death, but
my lords, please.
Only a revenue record.
The birth is recorded, my lord. Jama Bandi, annexure P12, page 97, where my mother and myself are both recorded. Bottom of the page, my lords, 96, and then 97, top of the page. This is the Jama Bandi. Your Lordship has this, my lords. May I read, my lords? Yes. Bottom of the page 96. The Circle Officer Vide order dated 11/12/2015 and mutation case number so-and-so. The name of Reja Khatun has been substituted by virtue of inheritance to Rezak Talukdar, mother, Reja Khatun.
This mutation is changed in 2015. What was the earlier mutation?
May I just take you to page 94? Her father's name is given here, my mother's father. So my name is on 97. Name, father's name, address to Pattadar, 94, my lords.
Yes.
Sri Nurul Islam, father Kalimuddin. This is my mother's father. My mother's father, my maternal grandfather. And then my mother's brother.
So even this will not help you because this is again 1982 settlement, the entry. The cutoff date is 1971, March 1971. So you have to show that this maternal great-grandfather was recorded as owner of the property. First you have to show that some XYZ person is recorded as owner of the property prior to the cutoff date of March 71. Then you have to establish your pedigree with him, that how your relationship is established.
So my great grandmother is there in 60s.
Because this is also an order of collector of assistant settlement officer of 82.
My lords, the Jama Bandi speaks to the Gaon Bura, which is annexure P10.
Unfortunately, there is a misnomer of the name Jama Bandi. This appears to be in the consolidation proceedings. This appears to be a survey conducted for the purpose of consolidation.
Yes, my lord.
There is a difference between a Jama Bandi is a record of rights in the revenue record depicting the ownership rights of the.
Yes, my lord.
And no difficulty, presumption of truth is there, rebuttable. But the cutoff date is of 71. So one has to be recorded as the owner, co-owner, joint owner.
P1 and P2 are prior to 71.
P1 and P2 are not Jama Bandi.
No, my lords. P2 is a revenue receipt. May I just take you to that and then I'll take you to the Gaon Bura. P2 is a revenue receipt from my father's side and then I'll take you to the Jama Bandi, my lords. The Gaon Bura, which is P10. Which documents, my lords, we are trying to establish the family lineage here. The problem here is that in poorer sections, when there is death and the mother goes back, it is particularly difficult. The FT should have considered some of the mother's lineage. Please see. P2, my lords. P2, your lordship has this, page 37. Please see.
Unfortunately, P4 also doesn't help you. This is a voter electoral roll of 1985. Again, irrelevant.
P2 has my father, my lord. Subject name Moqsad Ali, son of Al Abdullah. 1968. This is 1968. Now, if I may take you to P10, this is the Gambura certificate, which names me Joynal Talukdar, son of late Moqsad mother Regina Khatun. So it names my mother.
P2, when the P2 name of your father?
My lords, P2, the name of the father, right on top of the page, my lords. Page 37, entry 1.
A landowner is some Bekunt Chandra Goswami.
Yes, resident of, subject name Moqsad Ali. I was a tenant. This is.
Dr. Menka, how can this document be treated as a document of your residence?
Then may I take you to P10, my lords, which is the Gambura.
Well, you can't be.
Let's take a Gambura. The Lordship may consider calling for the record before the tribunal, my lords. May I then take you?
Did you please show us something?
Yes, may I just take you to annexure P10, page 78?
Absolutely no.
This is Gambura, my lords. May I just take you there? Annexure P10, page 78. Your Lordship has this. My lords all have this.
78.
Yes, page 78. The certificate is issued that Mr. Joynal Talukdar, that's the petition.
Who has signed this certificate? Who has issued?
My lords, the Nurul Islam, the village headman, my lords. It's typical, my lords.
Under which law the village head can issue this certificate?
My lords, the land revenue regulations, my lords, specific to Assam permit this.
Please show us the provision. Please show under which provision this certificate can be issued. Though this certificate also does not help you. Voter list of 1997 mentioned.
It documents my mother. Yes, and Supreme Court Justice Nariman recognizes the legal validity of this.
No, we are not. We will see later on who has recognized and how it is recognized. First, show under which provision of law it is that authority is competent to issue this certificate. That's it. Then.
My lords, could I? If you could pass it over by a couple of items, I'll bring the hard copy of the.
Take up next week. You examine. You have first keep in mind the cut-off date of 71. Keeping that date in mind, see how you can correlate the documents. You have to have a sequence of chain of documents to establish that you are able to cross the cut-off date.
I'll do that, my lords. And I'll also bring your lordship's judgment, my lords, which recognizes the legal validity and the place of a Gambura in the context of revenue records.
Gambura, we are not out. The problem is the Gambura has not been examined as a witness. Without that, a document executed by a person or issued by a person will not be admissible evidence. That is your problem.
And see the contents.
Gambura would definitely be a relevant document for consideration.
And this certificate says only what?
Examined about.
This certificate says that the above-named person.
I follow.
Above-named person was included in the 1997 voter list. That is not going to again help you.
What my lords, the Chief Justice is saying. I will strive next week, my lords, to convince your lordships. Get that Assam right. Run a case with it. I'm grateful for my Lord's patience. Next week, my Lords, I'll. Yes. I follow. I follow. Yes, my Lords, I follow. I'll strive to do that next week, my Lords.
Yes.
Mother's now died. Mother's not alive. She's dead. She's not alive, my Lords. Thank you, my Lords, for patient hearing. I'm grateful.
May it please your lordship. Your lordships, the present specially petition arises out of a public interest litigation matter regarding an environmental matter concerning enforcement of statutory prohibition on PVC flex and plastic coated advertisement materials in the state of Kerala. My lords, the High Court had disposed of the writ petition by recording the state's assertion without issuing any enforcing or supervisory directions, despite continuous violations are being continued. My lords.
Notification को
My lords.
You're very well prepared. You understand the law very well.
Yes.
But the timing of this kind of litigation now that your own case in Kerala elections are coming, restrain the state from doing this, restrain from how many states we will keep on restraining? Well,
my lords.
The problem is this one that and people start fighting political battles also in this court, whether it is Kerala, whether it is A state or B state or D state. Now it's all prayers are only to embarrass the state government. That you create some difficult situations for them. We issue direction, it becomes difficult for them to.
My lords, other states like Bombay are also having such laws, my lords. Already government orders are being passed by the state government, banning the PVC materials completely.
Your government already passed the order. Your government has assured the High Court that they'll implement the order. There's a little hitch here because the validity of those orders are challenged by the Association of Flex Holders.
Yes, my lord.
So the bench has said that you implicate yourself in that writ petition, and that will be a comprehensive list on which you can canvass your case of validity and enforcement, whereas the other side can canvass its case that it is invalid and ought to be quashed.
But my lords, as a respondent, we will not be able to ask for any positive relief, no, my lords.
You don't have counterclaims.
Then, my lords, at least your lordships may kindly pass an order till the decision comes out in that matter, in the correct matter.
You people want to create some impediment in the own whatever the election campaign will be there. See, we are not there. Please see our role to play. We are unless there is some imperative interventions required in a matter.
My lords, I have handed over photographs.
High Court is conscious of this fact. They have issued some directions. If the directions are not complied with, the High Court will take care of that. You should continue to fight your issue before the High Court. Make sure that the directions are already there, the regime already there, ban already there. All those are implemented. Your problem is of execution, implementation, not of the laws.
Yes, my lord.
For that, High Court is the most suited platform.
Then I might, your lordship may kindly allow me to file a review petition before the High Court.
No, there is no need of review petition. You just approach the High Court that this is the notification of the issue. You have disposed of the matter. But despite these directions or orders in the past, this is how it's happening in the state. The High Court will take the remedial measures.
Your lordship may kindly at least pass a clarificatory order.
We will grant you liberty to approach the High Court.
Approach the High Court. Yes, my lords.
We have not done consent for the petitioner. we find that the High Court of Kerala has already dealt with the issue. If any further directions, if there is any need of further judicial intervention or or the need to issue directions, the High Court is the most suited platform to address such issues. So we will liberty to the petitioner to approach the High Court. We are not inclined to entertain this special issues.
Grateful, my lords. Highly.
Please, my lords. It was agreed by the order of the Uttarakhand High Court enabling the government to use land sealing land for the purposes of government construction without taking note of the fact that the division bench of the Honorable Uttarakhand High Court
Uttarakhand Division Bench does not consider Section 25.
But the
Section 25 gives quite elbow space for the High Court, for the state to make change of use of land.
I bow down, my lords, but these circulars, if you're not...
These are public utility activities. How can you, madam, stand in the way?
It's not some commercial
it's not private clubs being set up or something.
Lordship may see...
Constructing government offices is a great service to the society at large. Public at large.
There is very limited agricultural land and the government circular itself. Lordship may just have an extra P2. Page 33, apart from the division bench.
There is a general principle that agrarian land should be given to landless peasants.
Yes, ma'am.
Then only to be used. But see, if all these rules, policies can't override the parent statute. And Section 25 is very clear that the government can settle, instead of settling land for agricultural purposes, permit permanently any land for purposes which fall within public purpose under the land acquisition.
Plus the second ground,
And what are the purposes? One is housing of government servants and a de-addiction center.
Lordship,
both are equally important.
Very vital for the society.
Lords may kindly appreciate that the factual matrix of this case was also not appreciated by the High Court in this order. Lordship may directly have an extra P19.
So he's an intermeddler. God knows what is a land is going in the name of public interest. What kind of public interest is watching?
Lordship may kindly appreciate it wasn't appreciated.
If today the state acquire the land, use public expenditure and then provide these basic amenities. These are not even basic, these are the fundamental amenities which an area should have been provided.
I kindly appreciate there is a distinction between acquired land and sealing land because the objective of the Land Sealing Act is to promote agriculture and to give landless laborers. Whereas the Land Acquisition Act has a different purpose. But
absolutely, landowners let the landowners claim compensation or whatever right they have. Who is he unnecessarily?
I'm a resident of that area. The second, my lords, mischief of the government which was highlighted, which has come to light now. If your lordship would have an extra P19, it's a very serious thing that 39 SC/ST persons were given this land. And by if your lordship would just have that one document, my lords, perturbed by what the state of Uttarakhand has done to grab this land, my lords. An extra P19, my lords, it's a 2008 document written by the Tehsildar to the DM. And I will show that, my lords, in the counter affidavit in another petition, they have admitted that this is not surplus land. It has been allocated and is in possession of SC/ST persons. And now, my lords, they are just evicting them as encroachers, saying that our file is lost. Lordship may kindly have an extra P land.
No, we are not concerned. We will not go into this.
These
are all political stunts. That's all.
No, there's no political.
You don't appreciate this judicial time of the courts.
Lordship may kindly
look. Most privileged PIL.
My lords, this is a state document, my lords. This is agricultural land which is being snatched away from landless laborers.
Having some political agenda.
My lords may kindly hear me.
Very much. Thank you.
Lords may kindly hear me. Lordship may kindly
we will not
P19. Without hearing me, I can't be out of court. Lordship may throw me out of court, but after giving me a hearing.
We know that what kind of agenda.
19, this is allocated land.
Yes.
Lordship may give me the liberty to bring these documents to the attention of the High Court.
Wherever you want to go, you can go. You can withdraw and wherever you want to go.
Because
we know that what kind of agenda people have.
Because this is a disposed of matter. I may be permitted to withdraw. This is land allocated.
You can withdraw and go there.
But Lordship.
Say, as far as the mail, write down.
Look, I'm showing a state document.
Say, so far as the issue pleaded before the High Court, which has been adjudicated by the interim judgment dated 4 July 2025, comma, is the perfect view taken by the High Court, warranting no interference by this court. The petitioner appears to be an intermeddler who has been rightly ousted by the High Court.
Withdraw, I will file.
So, however, faced with this, comma, the petitioner relies upon some new document, Annexure P19, which was not the subject matter of judicial consideration, which was not subject matter of consideration before the High Court in the PIL filed by the petitioner. As regard to the validity of that order, comma, we do not express any opinion, comma, full stop, the petitioner or any other public spirited person shall be at the petitioner or the affected person shall be at liberty to have recourse in law, to have their recourse in accordance with you.
Highly obliged, my lords. Highly fair. Grateful, man.
Yes, item 15.
My lord, senior advocate Siu sir is leading us on this matter. I'm taking as short pass over.
What do you want?
Item 15. We are for the petition.
What is passover or dates?
Short pass over.
No.
Well, there is a petition under section 11.6. Since it's an international arbitration, page 41 is the clause.
Notice, issue notice. Well, how are you going to serve them? They don't have Indian address here. Anyway, it is your edit. Issue notice returnable in Swansea.
I am so obliged.
Lords, this matter arises from the Foreigner Tribunal's order. I'll straightaway take my lords to the lineage documents. The 1966 voter list is at page 36, my lord. My father, Karam Ali, is listed at 682. My mother, Kulsun Nessa, at 683. Likewise, on the voter list of 1970, my lord, that's on page 37. They are listed. In the voter list of 1970, my lord, they're listed at 825 and 826. This is at page 37, my lord.
Exhibit A and Exhibit B. Where is Exhibit A?
Exhibit A to the BFT case, my lord.
Exhibit A before the tribunal. Have you attached it now document with us before us? All right, where is the 1966 document? 1966 voter list of your grandfather. Father.
That page 36, my lord.
36.
Show us the connection that your father's name is appearing in 1966, 1970, and in your name is appearing as the son of so and so in the 1997 voter list.
At page 36, the 1966 voter list, my lord. My father's name is at serial 682, Karam Ali.
What is the name of your father?
Karam Ali, my lord.
Karam Ali.
And mother's name, Ulsan Nessa.
Just a minute, just a minute. This page 36 is the voter list.
Correct, my lord, of 1966.
So, how old is your father? He is 50 years old in 1966.
My lord, there is some discrepancy in the age.
That is the whole problem. Here it is Karam Ali. Now you are producing a certificate of 1964 born Karam Ali at 35A.
My lord, that is a minor discrepancy.
How it is minor discrepancy? Age. How old was your father in 1966?
My lord, that does not fall from the record what exactly his date was. His date of birth was.
70 years old. The 70 document.
May I proceed, my lord? Then 1989 voter list is at page 38.
I do not, sir. These are not the grounds on which tribunal has gone. Recently,
At serial 850, my lord. Well, as this is thereafter certified by the Gaon at page 31A of Kachumara village, where I resided initially, and my father was listed as a voter. And again at P2, my lord, 32A, this Gaon certificate of the Gaon of Mondera village. My lord, and the link and the lineage is also shown by the voter ID card, my lord, at 33A.
Certificate is authorized to be issued. The rest of all documents are contradictory.
My lord, the voter list, there is minor discrepancy in the name and age, my lord. Certainly,
The name is also incorrect, age is also incorrect, and you say minor discrepancy in the voter list.
But then thereafter, my lord, it is certified by the Gaon that.
Therefore, you are heavily relying upon the certification only. Under which provision of law this certificate can be issued? Please show us.
My lord, the precise provision I'll have to address, but my lord, in Rahim Ali, my lord, this.
See, your certificates of the way your father's name is completely different. The age is, with the passage of time, age is being reduced. In 1966, is 50 years. After 10 years, it's 140 years.
My lord's administrative error, typographical errors.
Typographical error. You have to seek clarification, and somebody should have been brought in a witness box to say that this age is incorrectly recorded. And ultimately, what happens? When the proceedings are starting, you are obtaining a surplus certificate. Surplus doesn't come in the witness box. Surplus has not seen your father.
The Gaubura has been examined. I may take my lord to.
You was the law certificate, keep on the same day to Dr. Menka's date. Shows that under the law, the certificate could be issued.
Very well, my lord.
Just come to the working student.
I'm grateful.
Lord, in 18, I am appearing in 18.2. Out of these 18 officers who had been compulsorily retired, prematurely retired, one officer's writ, your lordship had been pleased to, SLP was rejected by your lordships. But the service record is different in each case. In fact, let me tell your lordships, 18.2 is a matter. 18 matters were put up before the court on 17 September, on the day when they were heard. Out of 18, 17 judgment was announced on the same day. In my case, because the facts were quite different, this was the only one which was kept and reserved. And later on, however, the learned judge has taken the same view. Your lordship may come to page 540, what I want to show. Just have 540.
It's such a major. Performance from such a major.
Actually, this man is what happened.
I don't find that then none of them deserve. Why should
I'll tell your lordship the point in this case. His record is good. There was a vigilance complaint which was put up before the three-judge committee, which said as follows: the learned judge consumes liquor in his chamber during working hours and misbehaves with the advocates. Learned judge does not sit on the dais.
When you are examining this kind of misconduct, you have to draw difference between Punjab and Gujarat.
No, so I'm just responding. That's correct. Now this later on it transpires, this complaint was not mine at all. It is of somebody else. And in fact, this man, my lord, he says he's a teetotaler. He has never touched a drop in his whole life up to now. And he says it's ironical this complaint is made against. Just have 2 pages, please. I have nothing more to say. On my file, please see page 540 and then see the RTI reply at 542. Therefore, it is fine. Now, I say, my lord, please see page 5. Therefore, my case was, in fact, even when those 18 were argued, was kept separate. If your lordship will see all other cases, judgment is announced the same day.
No,
mine, it is on
which page you are referring to?
540.
For your satisfaction, 540.
This is the record, volume 2.
540 is something else.
18.2, my lord, Jayesh Kumar Krishan Kant Acharya versus Honorable High Court of Gujarat.
That's a difference.
Yes, 18.2. Volume 2.
Where are your ACRs?
Yes, it's all there. That is what the High Court produced. That is what was placed before the committee. At page 540. It runs into 2 pages. If your lordship will see those 2 pages. Your lordship has got it. 540, my lord is. Shall I read the ACRs first? 2003 grading is good. 2008 it says disposal assessed as poor for the quarter ending June and September. Grading is good. 2005 grading is good. 2006 grading is good. 2007, this is how they have put it up, my lord. But at the bottom it says good, outstanding. 2008 grade outstanding. 2009 good, reasonably good. 10 grading good. 11 good. 12 they have said something, then in the end grading good, reasonably good. 13 they have said knowledge of law, etc. Grading reasonably good. 14 good, very good. Now these are my ACRs. Now see the next column. Vigilance complaint VC1 of 651 of 14. I have just read it. In fact, I can read it again. Learned judge consumes liquor in his chamber during working hours, misbehave with advocate. Learned judge does not sit on dais, and so all witnesses return from the court. Status, order to be filed. Now just see before I go to the RTI, just see my disposal. Now just average grade means 100% disposal. I'll show that. Good means 100 to 125% disposal. And just average means 100% norms. So all my norms are met. I am meeting 100% norms or 125. These are divided into 3 5-year batches.
No, but how 542 help you?
Just see 542. It says in reply to your application, it is stated that application VC contained allegations against Shri V.S. Dave, the then principal judge, and other judges made by an advocate.
So the complaint that was filed was against one Dave, not against you.
Correct. That's the whole point. It's the same VC 651. Now please see this page 540. Vigilance complaint number is 651 of 14. This is not, my lord, he's a teetotaler. He says, I have been, this is a double whammy for me. I have been retired and then given this certificate of drinking. I have never touched a drop in my whole life. The officer, this is his case. He says, I go to the temple, I don't have food before I visit the temple every morning, and this allegation is being made against me.
That is his personal life. We have not.
Yes, but my lord, I say this.
Gujarat most rarely anybody. Otherwise, people are.
So my lord,
follow prohibition. They don't drink.
So who knows what would have happened if this was missing from this column 3 was gone. That is why the learned judge kept my case back, the division bench. And ultimately this is decided, and then ultimately the bench is pursued.
Page 539. 539.
Yes, my lord.
Poor in month.
Assessment of judicial work this is.
Most of the time you are poor.
No, my lord.
Inadequate, just adequate.
2001, my lord. Assessment of judicial work from 2001 in March, June, September. They say poor, this is divided for March, poor, September, good.
539 is from 2000 to 2016. It's for long 15 years.
Yes.
And see the column.
Yes.
2000 you are not assessed. Next is poor, for 1 month good, other is adequate. Then inadequate, poor, not assessed good. Just adequate, poor.
This is disposal. Just see now the definition of poor, good and all. This is disposal. This is not record.
That's why we are only wanting to point out.
Yes, no, but see the definition.
Whether you took drink or not, that may not be an issue which we will go into seriously. That particularly when no inquiry is held and no complaint is found to be there, that issue we can overlook. What we are concerned is that compulsory retirement is normally of the dead wood. You just want to chop off those who don't work.
So please read page 239 with 145. Page 145. Just see 145. Where these expressions are defined. These are disposal. These are disposal expression.
We are also concerned about the performance.
Yes. Please see that. What is the definition of poor? Less than 75% of norm. Inadequate between 75 and 90. Just 145. Volume 1, page 145.
Yes.
Assessment is also wrong, sir, because it says not assessed.
Not for 2001. That is for later year. If your lordship will see page 145, it says in evaluating the work of a judicial officer, in giving remarks of disposal, the following standard shall be applied.
Website 2015. First.
My lord, he was 53 when he was retired. And my lord, one other very important fact is that 1 year prior, he was promoted in December 14 as additional district judge, ADJ. And in 16 early, he is being retired within a year. This is a lot of very hard. That is the only reason why I am pointing this case out to your
right
lordship.
Now we must have been having blessing of this guy, good practice or good.
My lord, he is 61. My lord, what? He is 61. All that he will get, he has crossed the age of 60 years. All that he will get today, in the event I am able to persuade your lordship, is 8 increments in his pension.
We have just pointed out to you the performance page 530.
Lord, it is actually 2002 says good. Inadequate means 91 to 99% norms.
So the benchmark for the performance is that if you want to be an outstanding officer, you must perform 300% of the target, minimum target. So that's the way that it's not that the officer is taken by surprise. Everybody knows that if I am only performing below 100%, then I am not even adequate. I am below adequate. That is a uniform guideline for everyone. So before he started performing, he knew that what he is supposed to achieve for a good report.
Yes, there your lordship is right. That is there.
And we are not on any other issue but for this 539.
Well, just kindly see from 2001, these remarks also are not borne out from the record. Just see P1 first. P1. This is 2003.
Yes, 2003.
Where are you reading page?
It's like 360.
One to poor hai.
Not assessed. Then 367 it says not assessed. It was wrongly 367 not assessed.
I think 12 is also not. 12 is also not.
Also very, they were quite conscious of this fact that they are prematurely retiring. So first the matter was referred to a three-judge committee.
Correct.
Three-judge committee considered everything. And based on those recommendations have been approved by the full court. In a case where there is, yes, of course, it's not that full court is the final seal. Judicial review power is always there, we keep on interfering. But where the possible view was there, in judiciary you can't have just only the fence sitter.
Not actually. The High Court judgment does not deal with record at all. The High Court judgment is only all general observation. Please
That's why we don't want that your compulsory retirement should be founded upon that complaint. We will clarify in the order.
The High Court has actually gone very far, my lord. High Court says therefore in such circumstances opinion formed by the High Court on the administrative side cannot be interfered on the ground that it is formed without material.
That is absolutely.
The satisfaction of the recommendation of the administrative committee, standing committee, full court cannot be interfered with unless tainted by patent illegality, breach of procedure, etc. But nothing is discussed, my lord. This is all very general observations made. My record is not discussed. The point raised that this is not my report is not discussed.
You see, your record is there before the High Court when the view on administrative side is taken or view on judicial side is taken. Yes, sometimes
the complaint of integrity, nothing, Lord. It's at 53, his career is cut short. In fact, he only joined in 2000, and in 16 years, he has been asked to go.
He must not be regretting after returning to the profession.
Severely regretting, Lord. It's very difficult to first there are about 17, 18 of them. But anyway, I am only standing for him, Lord, because his record is the record of the officer whose case your lordship rejected on that day is drastically different, Lord. And they have all been, just kindly pass on, they have all been considered alike. Just see the record of some of the others, Lord.
So others may have been having
the case which came up on that day. Just see that record, that column vigilance complaint. There are so many. I have just been taken up with them because of that one vigilance complaint. Column number 4, vigilance complaint. Special judge has misinterpreted fact in the order. Then second vigilance complaint. That one Mr. Pradeep Bhai working as superintendent and judge are in collusion, collect money from the accused person, settle cases. It goes on like this, Lord. That
there also these were complaints only. There were no inquiry or no finding.
In this case, Lord, I am only saying, Lord, let it go for a reconsideration minus this report. The High Court may let it. High Court consider it afresh.
The problem is that it has sometimes very demoralizing effect on the administration of justice because the High Courts feel genuinely that the persons really don't deserve to be continued. And by now the vacancies have been filled up, the person appointed, it becomes a difficult task. Yes, but the view to some extent, even if it is erroneous, we can clarify that part.
This is what I wanted to point out in this case, that so far as this officer is concerned.
So item 18.1, my lords, it's a completely different case, my lords. There is not even an inadequate remark in the SCR throughout. It at the most is a reasonable. May I request my lords to have 18.1, my lords? And then High Court says in the order that there are inadequate remarks.
Even if we have a good ground to substitute our view, still it doesn't.
Two submissions. But two submissions, my lords. In 18.1. In 18.1, there is in the ACRs, there is not even in remarks of inadequate. That's one. High Court says that there is an inadequate remarks. That one. And then second point, my lords, is that 4 years back, there had been 244 candidates who appeared for competitive examination, out of which 8 has been selected. I was the one who has been selected amongst the 244, 8, 4 years back, and promoted under the competitive examination of 25% quota 4 years back. Throughout the ACRs are good, or at least a reasonable one. At least one or two ACR are reasonable. Lordship may have that 18.1, my lords. And then there is no vigilance complaint.
First of all, you can't apply the general service jurisprudence principles in the judicial services. Our yardstick, our parameters, our considerations must be of high pedestal. Because
no vigilance in
one field where you have to perform and perform 24/7.
Lordship may just have my performance. At least peruse that performance. I'm not requesting anything more. 18.1, your Lordship may kindly have page 391, 392, my lords.
Yes.
Lordships have annexure P13, volume 2, page 392 in 18.1. First, if your Lordship may peruse, it starts with reasonably good, good, average, then average.
Isn't good, nothing.
But that is, my lords, in 1994. But then after, throughout it is good. 1994, I was promoted and by way of competitive exam.
Criteria which Mr. Patwalia has just read out.
Yes.
That shows that for the purpose of getting an outstanding report,
Lordship,
you have to perform 300%.
What I did, my lords, if just kindly help.
Not a criteria which was kept in sealed cover and suddenly the High Court has put you some springing of surprise on you. It is not like that. All of you were aware that irrespective of the benchmark of 100, you have to perform 300 times, then only you will be ready to have output.
Remarks twice has been approved by the High Court. It says in that very report. It has been with reasons that my representation was allowed and my average remark was set aside, was changed twice by the High Court. And thereafter, my lords, in 2011, out of 244 candidates, 8 were selected, passed. And then after 4 years, I have been made to compulsory retire. There is no vigilance inquiry.
Vigilance inquiry must not be there. If the vigilance inquiry, then it's a punitive action.
No, my lords, kindly
all natural justice have to be complied.
Complaint is that I have written 4 books. Now, these are the complaints against me. I have written books.
See, please appreciate those who have been inside the functioning of the system. They know well. Many a times we have, you can even brand them as hearsay complaints. But normally we call them spoken reputation. Now you don't get a document. You don't get any proof of anything indulging. But the spoken reputation sometimes becomes so bad that you are prompted to take a view. Because I have been very clear about it. The benefit of doubt must go to the institution, not the individual.
Something against me somewhere on records, at least an indication. That's the only request. There's some indication on record. Lordship may kindly have the High Court's reasoning. Page 30, High Court reasoning, my lords, kindly have. The High Court's at page 30, what reasons they give is that the petitioner has been assessed inadequate, poor. But there is no inadequate or poor remark in entire ACR. These are all because this entire judgment passed in one point of time.
Must be doing some arbitration also. Must be
nothing. It's now she is a lady, retired one. She can't even go to. She is not even practicing. She is not even practicing. Also, she is not doing anything. She is only.
Then
this is stigmatic for her.
In terms of our order, in one of the cases, they are entitled to be considered for pension and other retirement benefits.
But now she is 61. She is not getting anything other than monetary benefits that she will be able to get. If at all your Lordship may consider to entertain this present petition. There's nothing further.
Whatever under the rules they are entitled to, we have clarified. We will clarify in this case also.
Not be forfeited. They will be entitled to pension. That they have been premature.
They have a qualifying service.
Yes.
Compulsory retirement, they get pension.
Stigmatic. This would be stigmatic, Malos.
No, not at all.
This is Malos in my High Court order. It says inadequate, poor. It is stigmatic.
That's a definition of your performance. That's got nothing to do with stigma.
From upholding the decision of the.
My lords, that case where please request consider removing the stigma my lords had done in the other.
Yes, upholding the decision of the full court on administrative side. To which the petitioner judicial officials have been compulsory retired in public interest. Everybody will do it. We have heard. So 61611 semicolons, another concept on behalf of the petitioners. You did not do anything.
My lords, this is the order.
They want that observation that it may not be treated as a statement.
They have.
This paragraph.
Sure.
Great.
On a general principle of law, the Lansing concept of right we argued that the High Court as well as this court just foreign judicial review, which also brings the administrative decision taken by the people of the High Court within their compass. Regardless of an opinion formed on administrative side, the High Court will exercise the judicial power, is entitled to evaluate the decision-making process and can well interfere if it is found that the impugned decision is not based upon sound, valid, and lawfully known reasons. Next paragraph. Since matters, since the people of the High Court considered the cases of batch of officers, it seems that the individual facts have not been, a comment is apparent from the impugned judgment that individual facts have not been dealt with in extenso. Consequently, an impression has gone as if some of the petitioners have been compulsory retired on account of specific complaints which were never inquired into, and will be no finding of guilt based upon principles of natural justice. So in this regard, we wish to clarify. In this regard, after the service reports, we wish to clarify that broadly, the full court of the High Court has been guided by the purpose of the petitioners while forming the opinion as to whether they have become deadwood and are liable to be compulsorily retired in public interest. We find from the record that such a view could possibly be formed especially in light of the benchmark guidelines prescribed by the High Court for evaluation of performance of the judicial officers. It is just clarified that each order of compulsory retirement passed in these cases is based upon overall performance of the officers and not referable to any specific unsubstantiated complaint, spoke allegation. The orders of compulsory retirement of restrictions are innocuous, not stigmatic, and merely in public interest. That's what we declare so. Next paragraph. Having done that, We follow our order is 14th February 2026, passed in SLP Diary number 74408 of 2025. In the case of the similarly placed officer, and make it clear that the impugned orders of compulsory retirement shall not cause any impediment in the claim of the petitioners for post-retirement benefits. Order course. That's it.
Great.
What's in 19, your lordships would have noticed that there are two impugned orders. Now, I just want to take you to the second one, but before that, let me just mention what has happened. As far as the Mussoorie Dehradun Development Authority is concerned, in 2003, we had a concessionaire agreement for the interstate bus terminal. Now, that was constructed, 20 years passed, and after those 20 years were passed, we had some small claim, etc., for some adjustment. The 23, they gave it back to us. Now, suddenly we are finding that the other side, after operating this terminal for 20 years, has hammered us with a 400 crore claim in arbitration, which is why, your lordship can understand we are a little nervous. Now, the technical point which we have come with is relatable if your lordship has the synopsis before you, where we have set out the two statutory provisions at pages C and D. I'll state it. Under section 11 and under section 12, a written declaration has to be made before appointment, where it is a section 11 process, that the person has that the arbitrator who sought to be appointed is not connected either with the subject matter or with the parties. Now, that has not happened here at all. That's number one. Number two, they pass a general order, which your lordship will just have a look at. Please just go straight away to that. At page 106, annexure P6, which starts at 105. Paragraph 3. On 27th August 2023, during the process, in para 3 at page 106, the arbitral tribunal passes an order. The arbitrators on their part declare that they have neither any interest nor have they anything to do with the dispute in question, much less pecuniary or other interest whatsoever in the subject matter of dispute, so as to undermine the expected and required independence and impartiality. It is further declared that they have sufficient and ample time and ability to conduct and conclude the proceedings expeditiously. So our point, the first point is that there has to be an individual declaration in terms of the schedule, etc. by each one. You can't pass a procedural order in this manner. 1. 2. The declaration is inadequate and short because it doesn't talk about the relationship to parties. It only says that we have nothing to do with the dispute. 3. And now here your lordship will find that there is an IA which we have filed, because we discovered subsequently that one of the learned arbitrators wrote us individual letter to one of the parties, which is also not adequate, which we got to learn of later. That's in IA number 55750 of 2026, and it's at internal page 4 of that IA. Yeah. 90, 100. Yeah, never received. We consider recent law. 23. Given to me now. Yeah, that's right. This is produced after that. That's right. Yeah. Yeah. Okay. This is probably on the law. I'm sorry?
How do you make out a case of violation of 12.3?
Yes. So can I just explain as to how 12? Because 12 requires a written. Please see minutes to. Your lordships have pages C and D.
I'll just clarify.
Yeah. Yes.
Your Chief Justice's question.
Yeah.
It's not 12.1 or 12.2. You must come within subsection 3 of section 12.
Yes.
To show that there is material that the fairness and the bias in respect of 5th and 7th schedule is disclosed.
Yes. So can I just answer that? So may I just answer that? The primary point, so I should just make it clear. My primary point is that 12.1a is not fulfilled because they are required to file a written declaration, and that is fatal to the process. It's at 2 stages. I'm sorry.
12.1, 12.2 can be substantially complied with. Procedural order takes care of it.
But that order also, as I read, doesn't say anything about part.
Understand. Now, this is where we want to see whether it substantially infracts the equality of arms of the parties in this arbitration process.
Yeah.
Otherwise, we're not going to interfere. Because you have to make out a case. What you're making out is a breach of 11.8.
Yes, I'm making out a breach of. You're
11.8,
yes.
breach of 12 subsection 1 or subsection 2.
Yes, 12.1a.
Our query to you is, Percy, if there is a breach, the procedural order substantially deals with that situation.
Okay.
It may be to a certain extent in short or not up to the mark, but it takes care of it, and you are not concerned because after that you proceeded to file your statement of defense, amended statement of defense.
Yes.
What is the case made out by you is an RTI reply with regard to 11.8.
You've seen that.
And now if you see the RTI
yes, please go to the RTI reply.
It comes on 4/9/2025.
Yes.
And your application is made after the lapse of 15 days.
Yes. So that RTI reply was
it is not to be taken into consideration in view of 13.2.
Yes.
13.2 says 15 days. You have not made the application within 15 days. And there, Mr. Diwan, we would have satisfied our conscience if on substance you made out a case that yes, this is an arbitrator who has been an arbitrator in an earlier.
Can I just, I have come here on a I don't want to impute.
Technical thing after the much water has flown.
But just see the water that has flown. In 2020, if you see my IA, please see my IA. Just look at my IA. In my IA, the other arbitrator, your lordship will see page 4 of the IA, Annexure A1. He makes a statement to one of the parties and just says, it doesn't disclose it to both, because your lordship is asking me on the substance.
Yeah.
Please just see. I'm a bit surprised when you sought my consent to be your nominee arbitrator. So this is to the respondent.
Yes.
In the previous 2 arbitration proceedings I conducted, to which the party is a party, in the first one, the High Court of Hyderabad nominated me as sole arbitrator in the instance of Haryana-based claimant party. In the second case, the company nominated someone else, and it is your opposite party company which has chosen me as the nominee arbitrator. Detailed awards were passed in both matters long back. That is the reason why I took time to think carefully about giving my consent. After going through the brief note, I realized that the present engagement does not have even a remote connection even with the 2 previous arbitrations conducted. Hence, I convey my consent to be nominated as an arbitrator on behalf of your company as requested by you. Please find enclosed.
This has a higher trust in the procedural order. That's why it is said there's nothing to connect with the present dispute and let the parties...
But this was not given to us. This was not even shown to us, my lord.
No.
Because, my lord, this is what is happening here.
Application for termination. And
termination
11.8. Termination case is 11.8.
Yes.
And in our understanding, 11.8 is substantially complied in the procedural order. And that is why the arbitrators also asked you to make out a case of breach of 5th or 7th schedule. No case was made up.
Very well, I'm grateful.
This situation. Thank you.
Item 20.
May it please your lordships. Urgent judicial attention is required, Your Lordships. My fundamental rights are at stake. Article 14, Article 19, Article 21, everything is at stake, Your Lordships. There's a case pertaining to getting my accounts freezed, Your Lordship, by 4 states, 8 districts, Your Lordship.
What about the victims' fundamental rights?
I'll clarify that also. 4 states, 8 districts.
Procedure established by law. If you are aggrieved, go to the criminal court or to the high court.
I'll tell you, Lordships. I'll clarify that also. 4 states, 8 districts, Your Lordships. How can I go to all the 4 courts? Multiplicity of litigations, Your Lordship.
Victims are in 4 states. They lost their money in 4 states. Now you'll have to walk the hard way.
Lordship, what is happening?
Not get the convenient route of Article 30.
At the end of the day, even I am also the victim of the circumstances, Your Lordship.
Everyone is
Even for a small suspicious transaction, Article 14, right to equality, has been violated, Your Lordship.
When not only a mule account, you are continuing to be so in the litigation.
Lordships, but 4 states going there and finding one jurisdiction, there will be jurisdiction nightmare, Your Lordships. Because this... Deeply obliged.
Yes, item 21.
Your Lordships, learned senior counsel Mr. B. Sharma is appearing online.
May I please, Your Lordships? I am appearing for the petitioner who are the High Court employees. And one of the corrected 2 SLPs are pending before Your Lordships. One from the Superintendent Judicial Officers. Well,
in fact, Lordships had passed that order asking the High Court to decide because we were against the interim order, and then the matter was referred to the full bench, Lordship, and the full bench gave in our favor, state's favor.
So accept notice. We'll examine. Accept notice.
The High Court employees will get less than the...
Find out some solution. You can't have this kind of anomalous situation. High Court employees get lesser than the district court.
There are 2 PILs, Lordship. No, actually, the district court part also, Lordship, that is per inquiry because I'm peculiarly in the state, Lordship, there are state rules. So far as the High Court is concerned, the rules are actually under 229(2). And
may I point out one thing, whether the 6 CPC pay structures are being given to the subordinate judicial employees.
I'll file my reply. I'll file my
reply. The 6 CPC recommendations have been implemented in respect of subordinate judicial officers. And payments have also been made with an undertaking. So we wanted to have it with an undertaking, if possible.
That's it. All right. Next item 22.
Please. 22. Please, Your Lordship. Your Lordship, this is a public interest litigation, Your Lordship, where we have challenged the provision section 16 of the Chief Election Commissioner and Other Election Commissioners Act 2023. Your Lordship, there is a blanket immunity in this clause, whereas just...
Why this kind of seasonal litigation start coming only when the elections are there?
Your Lordship, this is a very important issue, Your Lordship.
Yes. Every issue is very important.
Your Lordship, this immunity is not even available to President and Governor, Your Lordship, which has been given by this Act here in this Act of 2023.
Yes.
So, Your Lordship, I just submit. Your Lordship, this is also important, Your Lordship. That
vague and evasive, a complete wide and wide. There is no law pleading in this court. And nobody knows the basic tenets of how the petition is to be drafted. Absolutely absurd petitions after. Very unfortunate kind of.
Your Lordship, only we have challenged one provision, Your Lordship. It's not that we are raising any...
Ask first of all your office of youngsters to learn what is the law of pleading. How to draft a writ petition.
Your Lordship, the only limited question is there. That's why very short petition.
All right, you want us to dismiss or you would like to withdraw and file at an appropriate. First go, approach the authority, then come have follow.
I will withdraw this, Your Lordship.
The popularity slogan is not
obliged.
Council for the petition seeks and permitted to withdraw this petition with liberty to approve the concerned stakeholders.
Lord, there are 3 or 4 matters impugning the same order. I am in the first one. Lord, I will tell you, Lordship, the facts are somewhat interesting. So what has happened is this, we are in appeal against the order of that part of the division bench's order, which has set aside, Lord, the order of the single judge, Order 7, Rule 11. There are, Lord, a batch of cases. Therefore, I must tell you, Lordship, Lord, some basic facts. Lord, there was a 7-time member of parliament called Mahendra Prasad. Lord, he has passed away now. He had extensive businesses and properties. One of the probably the richest MP who has been in Delhi for 50 years. So, Lord, he had a wife called Satula Devi. And he was living with a lady called Uma Devi. Both claimed to be wives. Now, obviously, Lord, the dispute is about the estate. Estate is large. So, Lord, what has happened is the MP, Lord, made a registered will in 2011.
Probate suit pending, declaratory suit, probate suit pending.
Yeah, yeah. Lord, sorry. So the wife, Lord, files a suit after 50 years. The wife, Lord, to cut it short, the wife has filed a suit. She's also dead now. She files a suit. Yes.
Also coming to picture, we do not know where it manufactured, who has tested them, where were they brought, and all these things. But these are all question of facts, essentially.
But Lord, I will therefore not tell you Lordship any
dispute. Has merely paved way for the determination of these issues. The real central issue will be in the probate.
That's a probate.
A probate matter.
So probate is going on. There is no dispute on that.
All other issues are also.
Lord, the law is, with great respect.
Yes, pay करके रखती है and order देती है.
One court has to partition.
Lord, your Lordship, sorry. Your Lord. What are you saying? He's saying the same thing. I told him there's a position.
Anything on we'll have an easy way out. Let it be decided on in fast.
I know that of course. Oh, let them be legally issued.
Exactly. 14. Not a 14.
So, Lord, I will tell Lordship some 2-3 facts. I am not taking Lordship to any disputed fact. Yeah.
The suit should be decided or taken up after the probate is decided.
That is one way.
But restoration of suit by the High Court
stay of suit.
But make this
better course which the High Court division may rightly observe is let the suit await the probate decision. Probate is an in rem decision. It should be. And let us say, Mr. Rohatgi, they are not able to prove the probate, have the probate on the will. Your suit would naturally revive and what you say as intestate succession and partition, everything will come to the fore.
No, so only one thing I want to say. Lord, I quite understand what your Lordships are saying. I don't, Lord, have a quarrel really. Only one thing I want to say. So, Lord, the suit is filed, also questioning the will. That, Lord, is not possible if a probate is pending. That is a Lordship judgment. So now let's keep that aside. Now, Lord, for the other reliefs, as the Chief Justice put it, she says that I gave gold in 1971 to my husband, who was an MP. He was not a qualified engineer. And he used that gold to set up a vast empire today, which is of thousands of crores. And therefore, my Lord, that law that I would be entitled to this, that, and the other because it was by treason, etc. Now, what is important is the suit is filed 50 years after, my Lord, this so-called 1971, when she gave the gold and the husband started living with another lady in 1974, etc. Now, what is important is this, my Lord. She also filed a writ by saying that the husband was suffering from dementia. So she said, appoint me as a guardian, I'd like to kind of a situation, because the Mental Health Act doesn't apply, this doesn't apply, etc. In that spirit, my lord, she has expressly stated that all the properties are of the husband, and not, my lord, that she provided, my lord, the corpus by way of this gold, etc.
Property in the sense that she is not disputing in the suit also. The properties actually were in the name of the husband.
But my lord,
now saying the source of generating these.
Does it take 50 years, my lord, for somebody to realize the source?
But you see, the only difference is that suppose a complete stranger comes and jumps into a pending litigation saying, no, this entire empire is my creation. We will be the court will be very, very doubtful in accepting it. She is not a stranger. She is, after all, the first wife of the.
And she has filed a suit, my lord, against me. I am the wife of predeceased son of the plaintiff. I mean, look at what is, my lord, going on. I mean, she has 3 sons, my lord. I am one of them, one branch. The other 2 branches, my lord,
other 2 disowned.
They were disinherited in the will. So the 2 sons and the mother gang up, my lord, against the predeceased son.
Because they are threatened by the influence of the other lady. The other lady's influence appears to be overwhelming.
So, my lord, with respect, my lord, the 1 or 2 things I want to say.
The best way is let the probate proceed. In the meantime, let this suit be kept in abeyance.
Very well, Lord, that is a lordship pleasure. Because the judge dismissed the suit.
In the impugn order, Lord, they have already been consolidated. So it's before the same judge.
Consolidation is something different. But it must await. It must await because consolidation again takes a problem.
The liberty. There is one small issue in that road only. There is one witness to be examined who is the only witness who is alive today who can talk about this gold. So that witness examination should happen, not for which an order is
no. The suit must await. Otherwise, the suit is hit.
Just see the last paragraph.
1 second.
Just see the last paragraph, 71.
The judge has mixed up the facts of the LPA of this.
The IA
should have written a separate judgment. All LPAs are mixed up. All
about the court. If he dies, Lord, how will this suit be decided? That's the only problem.
Suit
I'm
has
not
to
saying
await.
suit should be decided before the probate. Suit will have to be decided after. But the proceedings should go on in the suit. That's all.
What do you mean proceedings should go on? You will have
there is an important examination that are already.
I'm sorry, but that can't be. You will then have conflicting positions in a suit and a probate. How can that be?
There is already a consolidation order at para 71.
That should be set aside.
Different jurisdictions.
They're completely different jurisdictions. One is in REM, one is in.
No, it's because the same judge now. Right together. Page 45, Lord, it is both are on the original side.
The original side is all right, but the jurisdictions are completely different.
And that your lordships also have said for
that instead of word consolidation, the suit and the probate proceeding will be before the same judge. But
that's what has been done, Lord. Para 71. Just see para 71.
The lordships decide one after the other.
What is consolidated?
Consolidation cannot.
Yeah.
The character is different.
Second thing, the suit will continue, the evidence, etc., can continue, but no.
Yes, that is
no final decree.
No, absolutely.
Probate matter is said.
That
will help.
But it will lead to conflict.
No, evidence will not conflict. Only evidence is to be recorded.
It is before the state judge.
It will rather help the party. Both sides will be benefited.
The division bench also was of the view that the suit can be stayed.
Yes.
It's recorded. So if the suit is stayed, it can't proceed with evidence. You also see that they have not challenged that. Just see that part.
There are certain exceptions to that, Mr. Rocky. What Mr. Singh is pointing out is also very relevant.
Yes.
There may be a situation where a person is in poor health or a person may be leaving the country, etc. In these cases, there can be an evidence recorded subject to the maintainability.
That's right.
Time be fixed.
So, below para 70 records that
Seen that.
Yeah. And in any case, Milord, whenever the suit or whatever proceeds should be uninfluenced by this order. So any other proceed, because this will have an impact.
So leave granted. We have heard from some councils. on behalf of the appellants as well as Principal Counsel representing the respondents, contesting respondents who are on caveat. Upon consideration of the matter in entirety, we affirm the view taken by the High Court. So far as a restoration of this suit is concerned.
CSOS 03 of 20.
So far as the restoration of civil suit OS 203/2022 is concerned.
However, in case the
we deem it appropriate to modify para 70 and 71 of the influence judgment to the following limited extent. One,
because we have said it can be stayed, we consider.
The probate proceedings and CS in bracket OS 203/2022 shall be entrusted to the same one single judge as per the prerogative of Honorable Chief Justice of the High Court. While both the cases shall be preferably taken up of hearing simultaneously, there